Good afternoon, everyone, and welcome to this Guildford Chambers webinar. My name is Laura Smallwood. I'm a barrister and member of the property team at Guildford Chambers. The webinar will last approximately 35 minutes. If you have any questions, do please email me. My email will be on the concluding slide and I will respond. I should say that the slides will be sent to all attendees afterwards. I thought that it would be useful to survey the situation for landlord and tenant practitioners in the light of the array of changes that have been in place due to COVID-related measures. In the past few months, we've seen extensions, amendments, relaxations, and now we have more legislation on the horizon. So in this webinar, I'm proposing to cover the following topics. I'm going to look at the state of play procedurally and in law in possession proceedings, and also relating to other remedies relevant to landlords and tenants. I will take a look at tenants' COVID defences to rent arrears claims in the light of a recent High Court authority, and I'm also going to provide an overview of the government's scheme for dealing with coronavirus arrears in the form of the Commercial Rent Coronavirus Bill, which was introduced a couple of weeks ago to Parliament. And finally, I'm going to take a brief look at pandemic-related issues which have arisen in 1954 Act business tenancy renewals. So first of all, looking at procedural matters. We've all been living with the overall arrangements for possession proceedings in England and Wales, but happily these came to an end on the 1st of November. So you'll recall that these were aimed at reducing the volume of possession proceedings and instituted a two-stage process for proceedings, a review hearing and a substantive hearing. Well, that has all gone, as has the COVID-19 case marking provision and the prioritisation of certain claims, such as those relating to antisocial behaviour. The situation now is that we all follow the procedures set out in the CPR and the practice directions. We've also been living with PD 55C, the temporary modification of Part 55, which started when the stay on possession proceedings was lifted last September and is due to continue until the 30th of November, so next week. I have happily been telling solicitors that PD 55C was soon going to be history, but I'm afraid that's not quite the case in the light of the 137th Practice Direction update. This has amended PD 55C so that it will continue to have effect after next week in two respects. Firstly, it will continue to apply in relation to all claims issued before the 1st of December of this year. And secondly, it will continue to apply as to paragraphs 6.1 and 6.2 in relation to any claim issued between the 30th of August last year and the 30th of June next year. Now, in practical terms, this means that the so-called coronavirus notice lives on. This, you will recall, is the notice setting out the claimant's knowledge of the effect of coronavirus on the tenant and their dependents. It has to be given to the tenant at least 14 days before the hearing, and you must take 2 copies of the notice to the hearing. I have to say that I've only had one judge ever make reference to the coronavirus notice, but it is a mandatory requirement and we are going to have to continue to produce one until the end of June next year. I should say that paragraph 6.1 also refers to notice of compliance with the pre-action protocol for social landlords where applicable, and that too is going to continue until the end of June. Moving on then to notice periods for residential premises. This was, of course, a major effect of the Coronavirus Act, but since the 30th of September, we have been back to the pre-pandemic position for England. It's not the case yet in Wales. That won't resume until the beginning of next year. But I mention notice periods for two reasons. Firstly, do note that the relevant period during which there is power to impose revised notice periods continues until the 25th of March of next year. So there is a small, albeit remote, possibility of reimposition of revised notice periods if the situation were to change dramatically for the worse. Secondly, there are new Forms 3 and Form 6A for Section 8 and Section 21 notices that have been issued with effect from the 1st of October. The Form 3 has actually been renamed. It's now a notice of intention to begin proceedings for possession. But what you will notice about both forms is that they have been simplified. There's a lot less verbiage, a lot less information, and the overall effect is that it's far clearer for the recipient, which has to be a good thing. Finally, do check that the correct prescribed form was used for the time that the notice was served, because as each adjustment to the regulations and the notice periods has occurred, a different form has been issued. So do make sure that you have the right one in place. Evictions resumed in June, of course. There's been an inevitable backlog in the county court, and I have found that there are varying lengths of delay in getting a bailiff's appointment. I've certainly found that district judges are not particularly receptive to applications to transfer to the High Court for enforcement. In relation to evictions, obviously they are now back on track, but I would draw attention to the fact that the government request that bailiffs should not carry out an eviction if they are made aware that anyone living in the property has COVID symptoms or is self-isolating does continue. I haven't come across a case where this has happened, but I did have one client who was very concerned that COVID symptoms would be used as a ploy to thwart the bailiffs, and he therefore went to the bailiff's appointment armed with some lateral flow tests. Whilst we're dealing with moratoria, of course, the moratorium on forfeiture for non-payment of commercial rent is also in place, and that continues until the 25th of March next year. It applies to forfeiture by action or by physical re-entry, and it applies to any sum due under the tenancy, whether that is rent or service charge or insurance. Don't overlook the ramifications of the debt respite scheme on obtaining possession. The debt respite scheme was introduced in May of this year, and it is a permanent scheme. It's not COVID driven, so it is here to stay. The situation is that if a moratorium, either a breathing space moratorium or a mental health crisis moratorium, is in place, then in relation to a moratorium debt, the landlord cannot serve a Section 8 notice on rent arrears grounds under Schedule 2 of the Housing Act 1988, and he cannot take possession of a dwelling house let to a debtor having served such a notice. Further, he cannot take a step to enforce a judgment or order or enforce a warrant, start any proceedings, or apply for default judgment. There are specified exceptions to this in the regulations, and it is possible to apply for permission of the court to take any of these steps, but the default position is that they are not permitted. However, there are no restrictions during a moratorium on the service of a Section 8 notice on other grounds in Schedule 2 of the Housing Act or on serving a Section 21 notice. Oh, I'm sorry, I have rushed through my slides. Turning to other remedies, there has been, of course, a restriction on commercial rent arrears recovery, and the number of days of net unpaid rent that were required to exercise CRA rose inexorably during last year and into this year. And the situation currently is that CRA is only available where there are 554 days of net unpaid rent when notice of enforcement is first given. And that too continues until the magic date of the 25th of March next year. I'm not intending to deal with insolvency rescue procedures in this webinar. There have been several high-profile cases relating to CVAs where the position of landlords has featured, and that would be a webinar in itself. But what I am just going to deal with is the new regulations relating to winding up petitions, effective for petitions presented between the 1st of October this year and the 31st of March next year. The restrictions on statutory demands and also the need to satisfy the coronavirus test for petitions has ended, but there are continuing restrictions on petitions relying on the ground that the company is unable to pay its debts. However, from a landlord and tenant perspective, the important thing to note is that a petition debt must not be an excluded debt, and that is defined as including rent or any payment the tenant is liable to pay under a 1954 Act tenancy. So for practical purposes, there can be no winding up petition by a landlord for a tenant's commercial rent arrears. That takes me neatly into tenants' COVID-19 defences to commercial rent arrears. In a webinar in the summer, I considered two decisions of High Court Masters relating to the effect, if any, of forced closures of commercial premises due to the pandemic on tenants' liability for rent. Those decisions were Commerce Real Investment Gesellschaft MBH and TFS Stores, and Bank of New York Mellon International Limited and Cine UK Limited and others. And in those cases, arguments raised by the tenants based on implied terms in the leases, failure of consideration, frustration, insurance and rent cessor all failed, and the landlords were able to have summary judgment. As I say, they were decisions of masters, so not binding, but we now have a High Court authority in the form of London Trocadero 2015 LLP and Picture House Cinemas and Others Limited. This is a decision of Robin Voss sitting as a Deputy High Court judge. The facts were that this was summary judgment applied for by a landlord on £2.9 million of rent and service charge arrears under two leases of cinema premises at the London Trocadero venue. The leases provided that the premises could only be used as a cinema, and the landlord did not warrant that the premises could be used as a cinema. The pandemic struck, the cinema had to close, the tenant stopped paying rent, and the scene was set for these proceedings. The tenants had two main planks to the defence. Firstly, the tenant argued that the leases were subject to implied terms that rent did not have to be paid for periods when use of the premises was illegal or the takings fell below the level anticipated by the parties when the leases were entered into. And secondly, the tenant argued that there had been a failure of consideration or failure of basis on the grounds that the payments due under the leases were for use of the premises as a cinema, so that nothing was due for the periods when the premises could not be used for that purpose. The judge's decision was that the tenant failed again. In relation to the proposed implied terms, the judge found that they did not meet either the business efficacy or obviousness tests, and they were inconsistent with the terms of the leases. The judge rehearsed Lady Justice Carr's summary in the recent U Design Services case as to when terms will be implied, and he also referred to Lord Newburger's statement in the Marks and Spencer case that the question is whether without the term the contract would lack commercial or practical coherence. The judge said that the fact that the risk lay entirely with the tenant, because of course there had been no warranty given as to the use of the premises as a cinema, did not in this case lead to the conclusion that the leases lacked commercial or practical coherence. He said that requiring the tenant to pay the rent, even though the premises could not be used as a cinema, didn't deprive the contract of that necessary coherence. In relation to obviousness, he said that where the landlord gave no warranty that the premises could be used as a cinema, it wasn't obvious that the tenant should be excused from paying rent when they could not be so used. And likewise, where the parties had provided for rent suspension in the event of certain insured risks, and in this case, fire was one of those risks, an implied term was not obvious. In fact, the judge said that it was an inevitable conclusion that it wasn't obvious that a term for suspension of rent in other circumstances should be implied. In relation to the proposed implied term as to suspension of the rent when attendance levels fell, you won't be surprised to hear that the judge thought that that was simply too uncertain. It was impossible, he said, to determine whether suspension should be triggered other than in the case of a complete closure. In relation to the failure of basis argument, the judge held that the tenant couldn't establish a failure of basis, although he said that if it had been able to do so, it was possible to sever the lease into periods so that there would have been a total failure for the purposes of this doctrine. The judge said that use of the premises as a cinema was not fundamental to the basis on which the parties had entered into the leases. It was simply an expectation which had motivated the tenant. He also said it was the main benefit that the tenant is expected from the term, but it wasn't fundamental. Further, the leases had addressed the possibility that the premises could not be used as a cinema, because the lease provided, of course, that the landlord gave no warranty as to the premises' use as a cinema. The judge said that therefore failure of basis would interfere with the agreed allocation of risk between the parties, and it would be inconsistent with the leases. What are the practical implications of this decision? Well, what I can say is that there is further judicial consideration looming in that the Bank of New York Mellon case has leapfrogged to the Court of Appeal, and I understand that the London Trocadero case is also going to be appealed, and the two are likely to be heard together. So there will be further thoughts from the Court of Appeal in relation to implied terms, failure of basis, insurance and rent cessor arguments. Certainly, it does seem to me that the scope for tenants to defend claims for COVID rent arrears is diminishing, but each case is going to depend on its facts and how the particular lease has been worded. And Robin Voss in the High Court decision did make this clear in his judgment. So, as I say, we can look forward in the earlier part of next year to further judicial comment on this issue. Moving on, I would like to take a look at the government's proposed scheme for dealing with COVID rent arrears. And this is the Commercial Rent Coronavirus Bill, which was introduced to Parliament on the 9th of November. And the introduction to the bill describes it as a bill to make provision enabling relief for payment of certain rent debts under business tenancies adversely affected by coronavirus to be available through arbitration and for connected purposes. The bill establishes a binding arbitration process where landlords and tenants cannot settle disputes relating to payment of arrears that have arisen during the pandemic. The arbitrator will have powers to write off the arrears, to defer payment, and to reduce contractual interest. This bill is expected to be on the statute book by March of next year, but some of the provisions are retrospective. I'm not intending to go into this bill in great detail for the very reason that it is a bill and it will be subject to amendment. But I thought that it would be useful to give you an overview, especially as there are some retrospective provisions, and these should inform your advice to clients in the coming months before the bill becomes law. So what arrears are covered? Well, the term used is protected rent debt, and this covers all sums due under a Part 2 1954 Act tenancy, so rent, service charges and interest. Rent is protected if the tenancy was adversely affected by coronavirus, which means closure of the business or of the premises, and it is attributable to occupation during the protected period. What is the protected period? Well, it is from the 21st of March last year until the earlier of the 18th of July this year, or the last day on which the tenant's business was subject to restrictions. I've put the word England in brackets there because 18th of July 2021 is the relevant date for England. The date for Wales was in August. The relief that will be available, as I mentioned, is that the arbitrator may write off the debt either in part or in whole. He may give the tenant time to pay, including payment by instalments, although there is a 24-month long stop on that. And he may reduce any contractual interest, including reducing it down to zero. As for the timing of a reference to arbitration, it can be made within 6 months from the date of passing of the Act, but there is a power to extend. But so basically, this is a time-limited statute. What are the principles for granting relief? Well, in summary, they are the restoration and/or preservation of the viability of the tenant's business so far as consistent with preserving the landlord's solvency. There is an expectation set out in the bill that tenants should pay in full without delay. So clearly there will be a balancing exercise to be done by the arbitrator in determining whether there should be relief. There is also a new code of practice. This is the code of practice for commercial property relationships following the coronavirus pandemic, and it succeeds the previous code of practice for commercial property relationships during the coronavirus pandemic. It's very much in a similar vein. It sets out principles and best practice for negotiations. The intention is that rent disputes should be resolved before the bill becomes law. And it's also envisaged that the code will help to inform arbitrators' decisions. So it will be a document that is referred to. The bill contains provision for a temporary moratorium on the enforcement of protected rent debts. And as we go through this slide, you may have a sense of déjà vu when you look at the list of restricted actions, and you will be right to do so. During the moratorium period, which is from the passing of the Act until the end of the 6-month period or the conclusion of arbitration, a landlord may not use CRA in relation to a protected debt, or enforce a right of re-entry or forfeiture, or present a winding up petition unless he is owed a debt which is not a protected rent debt, or present a bankruptcy petition. So you can see the intention is to preserve the protections which were given to the tenants against certain forms of enforcement by the landlord during the pandemic. Additionally, though, you'll see that a landlord may not make a debt claim to enforce a protected rent debt. So that is actually an enhancement beyond the existing situation. Further, you can see that the landlord's right to appropriate rent must be used to meet unprotected rent debt before protected rent. And the landlord cannot recover an unpaid rent debt from the tenancy deposit. So the bill continues or will continue to cocoon the tenant from remedies at the landlord's hands. I mentioned retrospective provisions, and these are as follows. They apply between the 10th of November of this year and the date on which the Act is passed. And in that period, debt claims made for a protected rent debt will be stayed on either party's application to the court to enable payment to be resolved by arbitration or otherwise, which presumably means by agreement. An unpaid judgment debt on a protected rent debt can be resolved by relief by arbitration or by agreement. And what this means is that the tenant can effectively reopen his liability on the debt by seeking arbitration. And of course, in the arbitration, the debt may be written off either entirely or in part, amongst other things. It's also provided that judgment obtained on a protected rent debt cannot be enforced before the end of the moratorium period, and a bankruptcy order made by the court on a petition from the landlord against the tenant is regarded as void. So do keep these provisions in mind over the coming weeks and months when you are advising clients. I expect that we will see applications by tenants to stay debt claims for protected rent debt in anticipation of the Act coming into force and the retrospective proceedings with it. This, in fact, was the case also with the winding up petition restrictions last year. Various tenants applied when it was clear that the Corporate Insolvency and Governance Act was coming down the tracks and that there would be limitations on obtaining winding up petitions. Finally, I would like to move to spend a few minutes looking at pandemic-related issues in 1954 Act renewals. Namely, should a tenancy contain a pandemic rent suspension or other pandemic-related clause? There have been two recent county court authorities. They are W.H. Smith Retail Holdings and Commerce Real Investment Gesellschaft MBH, making a second appearance in this webinar. And that was a decision of His Honour Judge Parks QC, and Poundland Limited and Top Lane Limited, a decision of District Judge Jenkins at Brentford. Now, they are, of course, just county court authorities, but they are nonetheless interesting. The context is, of course, Section 35(1) of the 1954 Act that deals with the terms of a new tenancy, and I have summarised it there at the bottom of the slide. The terms of a tenancy on a renewal shall be as agreed between a landlord and tenant, or in default of agreement, determined by the court, having regard to the terms of the current tenancy and all relevant circumstances. In conjunction with this, we have the principles set out by Lord Hailsham in the O'May case, O'May and City of London Real Property Limited. Namely, first consider the terms of the current tenancy. The burden of persuading the court is on the party proposing the change in terms, and the change must be fair and reasonable in all the circumstances. In the W.H. Smith case, the tenants' unit, which was in the Westfield shopping centre, contained a post office. So it wasn't required to close during the lockdown because it was essential retail. However, there was greatly reduced footfall. I think it was down by about 90%. The parties agreed that there should be a new tenancy, and they further agreed that there should be a 50% rent suspension clause. But what they couldn't agree on was the trigger for the clause. The tenant argued that the closure of non-essential retail should be the trigger, whilst the landlord was saying that the trigger should be when the tenant was required to close compulsorily. And also, perhaps not surprisingly, rent was an issue between the parties. The decision in this case was that the correct trigger was closure of non-essential retail. The judge found that the landlord's proposal was empty because the circumstances to activate the trigger were highly unlikely, namely compulsory closure of essential retail. Interestingly, the judge commented that as the principle of the pandemic clause in the new lease was agreed, the tenant bore no OMA burden of persuading the court about the change. But he said, if that was wrong, essential fairness demanded it. So looking back there to the fair and reasonable limb of the OMA principles. And in relation to rent, on the evidence, the judge found that there should be no uplift to reflect the benefit to the tenant of the pandemic rent suspension clause. He said, and this had been the evidence before him, that this was something which all tenants wanted and the market had priced it in. Against that, we have the Poundland case. There was no agreement between the parties as to rent suspension or other pandemic-related clauses in principle. The tenant was proposing a 50% rent reduction during any use prevention measure, and the tenant argued that this would essentially modernise the lease. The tenant also wanted a proviso that it would be relieved of complying with the insurer's requirements during a lockdown, and a variation of the forfeiture clause to include a proviso that the landlord could not forfeit during a lockdown. The district judge's decision was that all three clauses should be rejected as far as inclusion in the new lease was concerned. In relation to the rent reduction clause, he said that it was not the purpose of the Act to redesign previously negotiated risks. He said that the tenant was seeking to impose a new risk on the landlord, sharing the tenant's risk to pay the rent, and that wasn't fair and reasonable. In relation to the insurance proviso, he found that there was no good reason for it. The tenant had argued that an inability to access the property during a lockdown would be a good reason for such a proviso, but the judge was not impressed with that. And finally, in relation to the forfeiture proviso, he found that it would significantly alter the commercial balance between the parties. He said that the tenant's risk was around trading and the landlord's risk was around the tenant's ability to pay the rent. Imposing this proviso would transfer or share the risk, which was the tenant's risk, when any government assistance would only be available to the tenant and not to the landlord. And therefore, once again, he found that it was not fair or reasonable to include such a clause in the renewed lease. As for the practical implications of these decisions, as I say, they're county court decisions, they're not binding, but they are nonetheless of interest as to an indication as to how judges will deal with these questions. There's clear tension between His Honour Judge Parkes giving the view that essential fairness demanded a rent cessor clause, and District Judge Jenkins saying that the allocation of risk approach meant that this was not appropriate. I think that it is questionable whether pandemic clauses will succeed in renewals where they are contested. Although this, the main important thing is that the allocation of risk and the parties' bargain should be considered. And this is a theme which, as I've said earlier, emerged in the COVID rent arrears cases that we've discussed. Of course, there is always the possibility for a tenant to insure against these risks. So I do think it is highly likely that there will be further judicial consideration of these issues, and it is a case of watching this space in the months to come. That brings me to the end of my review of tenancies and COVID. As I've said, the slides will be sent out to all attendees. If you do have any general questions about the issues I've dealt with in this webinar, please do contact me and I will get back to you. It only remains for me to thank you very much for attending this afternoon. I hope you found the webinar useful and to wish you a good day. Thank you very much.